Welcome to the Data Stream, the podcast that dives deep into the fast-moving currents of data, technology, and the law. BakerHostetler's Digital Assets and Data Management Practice Group, DADM, brings you this series, hosted by partners David Sherman and Nichole Sterling, to explore how companies navigate the complex and often intertwined lifecycle of data. From privacy and cybersecurity to advertising, AI, and other emerging technologies. I'm Charlie May, and you are listening to Baker Hosts. On today's episode, David and Nichole speak with Aleksandra Vold, a partner in BakerHostetler's Chicago office, specializing in healthcare privacy and compliance. Widely respected for her clear, strategic thinking, Aleks has become a go-to advisor for healthcare organizations, navigating complex regulatory challenges and security incidents.
So Aleks, thanks so much for joining us on the Data Stream. We're thrilled to have you with us. To start off, one of the things that you and me and Nichole all have in common is that we started our careers in litigation. How has that shaped the way you think about privacy and cybersecurity today, especially with your focus on HIPAA and reproductive health and healthcare advisory work?
Happy to be here. First of all, thanks for having me, guys. So my career path starting in litigation was not intentional necessarily. I guess litigation was intentional. I did a lot of trial advocacy in law school, but really actually came out of law school with my certificate, the law school equivalent of a major in soft IP, so trademarks and copyrights, and came out at a time when there was a major dip in the market, and especially on spending on soft IP. And so my thought was, how do I get in federal court? And that was as a litigator in data breach class actions. And so I actually started, I think, fairly uniquely on the plaintiff side.
Shame on you.
I know.
Shame.
I know.
Shame.
I have apologized. I've got an altar at night. I go and light candles. It was what was available. And honestly, I got a ton of experience, which is always really good. I've really been in data privacy my entire career as a result of that. Not at all knowing that that's where I would stay. I think my thought was I'll just be here for a couple of years and then I'll get back to my IP roots and I can continue to do all the IP events. I stayed in data privacy, obviously, throughout my career. And, what it taught me is plaintiffs' attorneys aren't super concerned with the law or the facts. They're concerned with how many people do I think I could say with a straight face I represent in this class action, which drives up the attorney's fees, right? And makes it more expensive for the entities who are being sued. And so that plays a role in a lot of kind of when we think about worst case scenarios is being sued for a lot of companies. And I think it's important. I always reiterate this to my clients is that a lack of a quality claim does not mean you won't be sued. In fact, it is just as likely. And so let's think about how this lays out in litigation, whether we're thinking about privilege and needing to kind of ensure we've got that good privilege structure around what we're doing, whether it's language should we use? And then really when we think about, okay, we're going to design our privacy structure outside of an incident in these particular ways, how do we anticipate what that will look like externally to enterprising plaintiffs' attorneys so that we can at least try to make it unappealing to them or harder for them to penetrate? But it was a very interesting kind of introduction into this world. I appreciate and hate all at the same time.
Diving into other very interesting things that have been happening in the world in the last few years, I wanted to talk a bit about DADM. So we've seen a bit of a shift in how entities and regulators are thinking about reproductive health privacy after the Supreme Court's decision in DADM. And then we saw a HIPAA amendment that went into effect, got vacated, and that was intended to put more protections around reproductive health. In this whole sort of ecosystem that we're seeing in the post-DADM world, what kinds of conversations have you been having with clients around reproductive health and privacy issues?
So much of the last 2 years of my life has been focused on reproductive health privacy laws. And what's really interesting is, so you're right, just after Dobbs, we saw HHS, OCR, the U.S. Department of Health and Human Services, Office for Civil Rights, that's our HIPAA regulator, come out with guidance essentially to consumers, which we don't often see. Usually they're talking to the covered entities. So to consumers saying, hey, consumers, remember, not every website is subject to HIPAA. And things like, period trackers and ovulation trackers, et cetera, may be able to use your data in ways that they wouldn't be able to if they were covered entities. So beware of what you share and be careful what you share. The concern being that these apps could be subpoenaed to get user information to kind of correlate when someone was, indicated in an app that they were pregnant and then suddenly they were not pregnant, and whether that indicated some kind of, pregnancy termination on their behalf. And then in the states where there is super restrictive laws on pregnancy termination, having those regulators go after women or providers, whatever the law allows for. And so there was kind of a concern generally that because states could now punish the seeking or receipt or provision of reproductive health care for women, we want to make sure we're not making it easy by kind of accumulating that information and making it available to regulators. So that truly, like, covered entities at that point were like, we still have HIPAA. Like, HIPAA, has barriers to what we can share with law enforcement. HIPAA is just kind of a baseline acknowledgement of patient privacy. And it tells covered entities and business associates to those covered entities in what situations they're permitted to share, but never requires a sharing other than to the patient themselves and to HHS OCR when there is an investigation. So kind of a growing concern, because one of the permitted disclosures is to law enforcement, that law enforcement in these states with the more strict reproductive health laws could come, and under HIPAA, we are permitted to produce information about a woman's reproductive health choices. So we had what I call, in short, the Repro Health Amendment to HIPAA. It's not the real name of it, but we'll call it that for shortness. Really kind of built in, listen, if there's ever a request, a law enforcement request that seeks reproductive health information solely for the purpose of kind of the mere act of obtaining, seeking, advising, or providing lawful reproductive health care, you are actually prohibited. There's not a lot of specific prohibitions in HIPAA, but here it was like actually prohibited. You can't do it. That makes a lot of sense, not only in kind of sphere of reproductive health, but really a government official, a law enforcement official should never be able to get into your health information when the provision of care was lawful, right? But obviously it was, highly politicized. There were several lawsuits that were filed, and in June of this year, it was vacated. That rule was vacated. So we no longer have those protections in place. So what's interesting, though, is that when we think about this rule being vacated, it's not like we were being catapulted back to the 1800s. Like some of these abortion laws in states when Dobbs came out, it essentially reverted state laws to the 1800s for their abortion criminalization laws. We were just kind of put back to like mid 2024, which doesn't seem bad, except that we have this confluence of also Dobbs coming out. And so in addition, we've got a new HHS, we have a new president with different ideals than our prior administration. And so you come back to a HIPAA that, is still nicely protective, but you have law enforcement officials, federal officials taking serious aim at things like access to abortion, things like access to family planning and transgender care. So the conversations are now very interesting because where HIPAA felt sufficient previously in the previous administration, because there were not these kinds of big actions happening, kind of taking grabs at reproductive health care information. We didn't have ICE activity the same way we do now. A lot of entities are asking, can we put up any additional barriers? And the reality is HIPAA is a floor. And the commentary to all of the various amendments to HIPAA talks a lot about the bedrock is patient privacy. This is a floor, and you are permitted to go above and beyond HIPAA. And so now the conversations are around what can we actually implement? Like what can we support? If we promise a patient, for instance, that we will inform them of a law enforcement inquiry about certain types of information, can we operationalize that if law enforcement's asking for tens of thousands of patients' information, right? And then kind of beyond that, how can we or how should we or how should we not kind of support patients in challenging law enforcement officials' authority to ask for this information? So there's definitely an evolution of wanting to do more. HIPAA is very onerous as it is, right? Like there's a lot there, very restrictive, but now entities are just trying to figure out how to protect that doctor-patient relationship and make sure that their patients are being honest with them and giving them real, honest information without feeling like if they tell a doctor this, it's going to end up in my medical record and, some official is going to get their hands on it because they're going to ask for whatever the information is. That really undermines the doctor-patient relationship and the efficacy of care. So those are really the conversations we've been having. In addition to that, we do have a lot of DOJ activity, state attorney general activity around transgender care. And so navigating what is a very sensitive subject with kind of unwilling, on the other side, fairly unwilling to cooperate and understand the sensitivity of the information involved. So lots of sensitive issues and just really trying to do the right thing for the patients without kind of getting into more trouble or, get more attention from regulators.
So I'm going to leave a quick pause here because I want to ask a question, and I don't know how you're going to answer this, but I'm curious just to follow up. Recognizing how politically charged and sensitive for all sorts of understandable reasons these are on all sides, and that our clients come from every corner of the political spectrum imaginable, how do you manage to address these issues? How do you stay neutral?
What is great about healthcare is regardless of who you voted for, there is an appreciation for patients and wanting to do the best for patients. So, I worked through the reproductive health privacy rule with entities that were full red state. No reason to believe that they were kind of in favor of protecting the information. They understood, and because it's such a highly regulated industry, they understood that this is the law, or was the law at the time, and we are charged with effectuating that law. And violations of the law are not good for patients, and the violations of the law are not good for the covered entities themselves, right? Like they will be in trouble. And so, especially around these sensitive issues, so like part of the reproductive health final rule was you had to get attestations. You had to kind of judge the reason for a request from law enforcement and try to figure out if it was prohibited, if it was for the mere act of obtaining, receiving, facilitating, et cetera, lawful reproductive health care, or if it wasn't, but it still had reproductive health care information involved. There were additional hoops that these requesters had to jump through. And a concern that I voiced and something we tried to address through kind of easy workbooks was not everyone is going to agree that this information should be protected, but we can't turn a blind eye and just assume, or not maybe, but because of that, we need to ensure that everyone is on the same page with the obligations under the law. And we need to audit on a regular basis, because if one person is doing the wrong thing, all those law enforcement requests are going to go to that person, right? And it's going to fall through the cracks. So it's just ensuring that people understand this is the law and following the law. And it really doesn't matter what your political affiliation is. If you hate HIPAA, you still have to abide by it, right? But no one hates patients and no one hates patient privacy. And so I think that's really helpful, just having that ethos of data protection really built in for the last 20 plus years to the healthcare industry.
Thanks. So bringing focus back to clients, right? Again, being in a client service industry, I know you've been keeping a close eye on everything from HIPAA enforcement to new state laws in places like Colorado and Texas to healthcare related AI legislation. What do you find is top of mind for your clients right now?
Doctors and nurses are natural innovators, and AI is here, right? I think we've all heard of it. And doctors and nurses are chronically overstressed and overworked. And so they are trying to find ways to bring in AI to alleviate some of the administrative pieces on their plate. They can do more bedside, they can do more research. And so with that, a lot of requests are being made internally. So it's not like the external vendor, sending an email saying, hey, we've got this new thing. It is the doctors demanding, we want this new piece of AI. The doctors, a lot of times, being very cool, are developing in all of their free time technology that they want their hospitals to both support and kind of monetarily, but also to actually implement in the care setting. And so the concern about how much AI is kind of coming in, a vendor 5 years ago, they have had zero AI, and now all of a sudden the vendor kind of software platform is substantially AI, and we haven't really reassessed whether that's okay or not. So I think the issues are, we say no to AI, they're going to do it anyway. And then we're going to have breaches because we're kind of having people disclose to these AI platforms or these third parties. But we need to say yes responsibly. And how do we keep pace with kind of the new law after new law after new law that's coming out? And so a lot of conversations just around, hey, can you look at this contract? This is what they're saying about data use. This is what they're talking about for secondary use and de-identification. Does this all make sense? And so just kind of making sure we apply the same rubric to AI is a big issue. And, talking to colleagues, just hired Matt Van Heist, formerly from the Illinois Attorney General's office in the privacy division, and kind of his view of the world on where AI is going. None of us really think that there's going to be a comprehensive federal AI law. And Matt agrees with that. In the world of multi-state AG discussions, the idea is he believes will come out and continue to come out are state-specific AI laws, which is, we've already seen that start here with a emphasis on patients understanding when AI is being used and potentially needing to, like in Illinois, they have to consent in writing for certain AI uses in mental health, getting their consent and ensuring that they understand what is AI and what is not. And so similar to the patchwork of data breach laws and the patchwork of, growing patchwork of state privacy laws, we're going to see the same thing with AI, and it's going to be very difficult, especially for multi-state providers and on the software developer side to ensure compliance kind of across the board. So it's really kind of the fretting around what random new laws have come into effect that impact us that we're not fully aware of, and how do we address that retroactively with software we've already implemented. We have multiple ways patients are coming in multiple facilities, and they could come in unconscious, they could come in for a pre-scheduled visit, they could be all over the place, and ensuring that we've got a unified message and a unified consent process is really, really difficult. So that's just kind of the AI fretting is what I'm hearing a lot about.
I know that one of the other big things you've been working with a lot of clients on have been these pixel tracking issues. So can you explain what exactly is happening there and why it's important in the healthcare context? And what's your take on how regulators and, if you want to tackle it, the plaintiffs' bar are approaching this particular issue?
Oh man, that's such a big question. I know I have given you very long answers, so I apologize. This is going to be another one. So just kind of backing up, broad view of how this all came about is there was an article in an online publication called The Markup within 10 days or so of the Dobbs decision coming down, which was a very interesting timing. But the article kind of salaciously announced that of the top 100 hospitals as kind of identified by Newsweek, the vast majority of them were, quote, sharing sensitive PHI with Meta, with Facebook, through the use of advertising technology in the pixels embedded on these hospitals' websites. That kicked off a flurry of freak out on the regulator side. So OCR on the covered entity side saying, oh my gosh, we were named, what is happening? And then the class action side as well. So what we saw from OCR after that markup article was a not massive amount of investigations begun, but like certainly a new avenue to investigate. Covered entities asking, essentially sending out breach investigation data requests all about their tracking technology on their website. OCR also issued guidance that stated that on a public website, so if you just go to any website at all, even if you're not a patient, you go to that website, these tracking technologies will always collect your IP address. And an IP address alone, according to OCR in this, I think the 2023 guidance, said that is PHI, which does not actually meet the definition of PHI. But essentially, they were saying if you are using any tracking technology without a business associate agreement, you are engaging in unauthorized disclosures of PHI. There was a lawsuit against OCR challenging that guidance, essentially saying that it was unlawful rulemaking because they were trying to change the definition of PHI. PHI has to be individually identifiable, like, reasonably likely to identify the individual themselves, and has to relate to the past, present, or future provision of care, diagnosis, or payment for care. An IP address and a visit to a website does neither of those things. I am on BakerHostetler's IP address 90% of the time when I am doing things, including, is this rash on my kid okay, right? That's not my PHI or my health information. I'm doing it on behalf of my child, and my IP address is that of Mr. Baker or Hostetler, but not Alex Vold, and certainly not my child. So there's a successful challenge to that guidance. The portions of the guidance saying that on the public website, IP address alone is sufficient to be PHI, that went away. But it didn't go so far as saying that website tracking technology universally was okay, and certainly didn't touch on the idea of once you're in an authenticated part of a healthcare website. So something like your MyChart or your patient portal, whether that would be okay. And so we've seen since that markup article an insane amount of class actions filed against healthcare entities. I think Baker is up to almost 200 that we are defending, most of which are in healthcare, but they've branched out to other things like tax preparation services and other, life insurance, et cetera. And so, again, kind of starting with the markup article, the freak out on the covered entity side was, what are we actually doing here? What does our marketing department put on our website? And is it okay? And so we end up bringing in third parties to do a kind of full deep dive into the websites, document the tracking technology used, document exactly what is being transmitted to the tracking technology vendors, and then assessing, really, does this rise to the level of PHI? And if it does, let's get it off. And then assessing whether it is more than a low risk of compromise to PHI such that notification would be required. So lots of internal investigations, and they're still happening. I think I started 2 just this week. So it's not, it's certainly less frequent than what we saw in 2023 and 2024. But entities are still kind of coming around to this question of, is this okay? And what should we do to look into it? On top of that, so that's just in the HIPAA space, the FTC revised its health breach notification rule, and that rule applies to non-HIPAA covered entities. That rule was revised to say, essentially, that any sharing of information, even if it's intentional and to a vendor, if that is not explained to the consumer beforehand, that is a breach. So something like if your privacy policy says that you will use tracking technology and disclose information for purposes of website analytics, but you don't say for marketing purposes, that technically would be a breach if you are using tracking technology for marketing purposes and you're sharing health information. So kind of going back to that, is it like period tracking apps or even like step counters or anything that kind of accumulates health information about the consumer? The question that needs to be asked is, like I said, kind of let's get our arms around exactly what is on our websites. And if you ask the marketing department, they're going to say, there's just these 4 pixels that we use. And when we bring in the third party, it's like, there's 36 different pixels from different providers. So really doing that deep dive, cleaning up shop. What do we need? What do we not need? Where do we need a business associate agreement? And then getting a process in place to vet new implementations of pixels and kind of getting some more control integration with the compliance and privacy office before those things go in place. Because a lot of our marketing professionals are like, coming from retail. Nordstrom does it. We should do it. That's not how healthcare works.
Only 36 doesn't sound bad.
This is in healthcare. So usually there is more control because we can't, under HIPAA, we have never been allowed to, sell patient information. There are certain things we've never been allowed to do. So the difference should be significant as between retail and healthcare, but 36 is still too many, right? Like when we think about what we're allowed to do and use and disclose, a lot of times 36 is One, marketing didn't even know that the other 32 were there. And so we're not controlling that. We don't have a use case, right? And under HIPAA, if we're disclosing PHI, we better have a reason to do it. It can't just we forgot to take it off and it's fine. It's not fine if it's no longer providing some kind of service back to the covered entity that we're using. So we've always had to be more controlled in that respect. A lot of what tracking technology is meant for in the healthcare space is amplifying public health issues, right? So things like embedding a pixel in an email to all Hispanic men over the age of 50 about colonoscopies. We want to know if they're clicking on that email, and then when they click on the email and go to the website, how much time are they spending? Because if they're not clicking or they're spending zero time on the website, we need to reformat how we're speaking to that population and make it more compelling for them so that they get their colonoscopy. It's not driving sales, right? It is about engaging the public in a way that's meaningful to them so they can take proactive, healthful actions, because there's only so many times we can call or send a postcard. And so we're trying to kind of reach them where they're at.
So, Aleks, when a cybersecurity incident happens, how does all of your advisory experience help shape your incident response strategy with clients up front? And what's the most important thing to get right from the start?
Oh, such a good question. Let's see. So the advisory experience helps because in healthcare breaches, the data is kind of wild. If I ask a client today, where is your PHI? It's only in the EHR, the electronic health record. That's never true. 12 plus years of doing incident response. Never have I ever had a healthcare breach where that ends up being true. We've always got so much information in PDFs and on file shares, et cetera. The advisory work does help is helping the client see the data in a way that makes sense in a regulatory kind of framework. So especially where we have a covered entity that is made up of multiple covered entities, making sure data ownership is figured out appropriately in a way that, like I said, makes sense to a regulator and that's defensible to a regulator, as opposed to just saying, we're going to notify everyone and not be concerned with whether everyone includes patients of a hospital we acquired and then shut down 15 years ago. We need to think through those types of scenarios so that we can really address the data from the get-go. And I think every breach is a little bit different. Hopefully, normally when I'm going through something like that with a client, it's their first big one. Usually we don't, despite all of the reports that like 79,000% of entities are attacked again and have another breach in the same year. We really don't see that happen frequently, especially in healthcare. And so being able to explain the data privacy issues that are going to be coming down the pipe is really helpful to them. Because a lot of times I think cybersecurity incidents, when they happen in poorly managed situations, it's seen as a security incident without regard to the fact that it will almost always be a privacy incident as well. And so making sure that we're keeping the compliance and privacy people fully engaged, even in the parts of the investigation that feel a little technical, because they're going to need that background. I think the most important part, or kind of how the advisory experience comes in, is once things settle down, certainly wouldn't do this, in the thick of being in downtime and everyone's hair being on fire. But once things start to settle down, I will give the client a sanitized version of two different things. One is, what is a data request going to look like? So for those that are not HIPAA, OCR is required to investigate any incident that impacts more than 500 patients or, in the health insurance world, members. They're required to do an investigation. The investigations are not uniform, except that there's usually maybe 3 questions about the incident itself. And then 80% of the inquiry itself is a deep dive into general HIPAA compliance. And so I give clients a sanitized version of that because I want them to start thinking through, how would we answer these questions? Not necessarily about the incident. Those are easy. but about how do we show we have logging turned on and reviewed? How do we show that we've got role-based access implemented? Like all of the kind of security rule obligations that they have. Because if we wait until the OCR investigation starts, we've wasted an opportunity to get things in better shape ahead of time. And then we're scrambling to both try to implement things and answer these requests in 30 days. So that's one thing I do. And then the other thing I do is part of the OCR request is generally a question about what recognized security practices have we had in place. There's a safe harbor OCR is supposed to take into account whether you have recognized security practices in place in order to reduce your fine if you were to get one. So I'm really proud of the work we do with clients on answering that question. So I'll provide a sanitized version of another client's response so they can see the breadth of what we're really looking for. Because that's where, even if direct questions are not asked about how great your program is, this is where we can really shine. So we want to make sure we're setting clients up to look fantastic to the regulators. And we can only do that if we give them a head start.
Those were amazing answers. And it's so funny, just like you, my practice is so split between incident response with a heavy chunk of advisory work as well. And that balance shifts 70-30 in any direction, depending on the month of, the year. Yeah. My answer would have been so different. But also what you said makes so much sense at the same time. Shifting for a minute, though, fun topics like things outside of work. I know that you are a mom of two and an avid runner. How do you juggle the intensity and unpredictability of incident response and advisory work with family life and wellness?
It took a while to figure it out. So I had my kids when I was mid-level associate. I joined Baker as counsel in 2018, about a month before my son's first birthday. So now I've got an 8-year-old and an 11-year-old. And it's really hard. I think that for a long time, there was just no sleep involved. I remember being pregnant with my youngest, 3:00 in the morning, the day before an OCR response was due, that another attorney had accidentally deleted the draft. Irretrievably deleted the draft. And so I was like, I had to rewrite it. There's no stopping for some of these deadlines and for a lot of this incident response work. I've got a sweatshirt that says, I'm nicer after I run. The reality is I'm a much better version of myself after I go for my runs or do my workouts than I am without. I have a saying that you have to tend your own garden, right? Because otherwise there will be no fruit later. So while today's run may not be great or, I'm not currently training for anything, I want to be ready for when I am in a few months, right? And that goes for any kind of hobby too. You have to keep it up. You have to maintain those hobbies so that when you're ready to jump back in, you're not like, I'm a stranger to this. It takes sacrifice. So I think it's realizing that you deserve just as much as you're giving to everyone else and making a schedule. That's the other thing is I have a running coach. She programs my training and that is as important. That one, I pay for it. So I don't want to disregard it, but I take that as an assignment. I will do that thing that day, just like I'm going to be on my work calls, just like I'm going to be at the volleyball game, just like I'm going to pick up the kids, right? So I think what gets measured gets managed, and you just need to program your life and curate your life in that way.
So I will just add that one of my two favorite things that Aleks does for the team here at BakerHostetler, one of those is that Aleks is responsible for what we have internally as our kudos thread on Teams, which is a fantastic thread where we can just post client feedback about positive things and acknowledge each other, which I think really helps too.
I started that, I think, in 2020. And I think that my post was, I'm in a bad mood. It makes me feel happy when clients say great things. So someone help me out. Give me some good feedback that you or another attorney has got. I mean, there's hundreds of replies at this point, and there's not, a lot of times there's not a good way to share these things, or you share, but you only share with the person's boss and not their peers. So I love that people copy and paste emails from clients that are this has been one of the best experiences, name the associate. And sometimes it's a first, second year associate. They have helped me sleep well at night. I like that, especially for new attorneys who may feel overwhelmed. This is like a big job. This is a stressful job. Knowing that they can make an impact and knowing that so many of their colleagues have gotten that kind of praise, that's really what they should aspire to, right? Like phoning it in and just like treating everything the same and just doing the documents and sending the emails. That's not only not enough, I think kind of a hollow existence to just be a worker at the email factory. Making like an emotional difference on these folks, on these clients, usually like the worst time of their professional career, is really what makes this super fulfilling. It's not like, yay, we got the letters out on the 60th day. Like that's not what makes me feel great. It's knowing that I provided clarity and a sense of calm and guided them through something in a way that was really impactful for them. And I think all of us that do this job have a bit of a hero complex. And so putting that on blast, I think, is really healthy and lovely.
The other thread that I will mention that I believe you're responsible for is the annual Halloween costume thread, which is always a very fun one to see everybody's kids on our internal teams and dogs and cats and whatever else they're dressing up.
Yeah, I think, you didn't ask for my thoughts on that, but I will give them anyway. I actually have never had a boss that is a parent. I think one time I've had two men with kids, but they had wives that stayed home and really were, unfortunately for them and their kids, not super present or active. They were, 7 a.m. to 11 p.m. types. And it made it feel hard. And I want to show people that parenting is something you can do well while you also perform well in your job. And so part of that is parenting loudly. And that means, including sharing what my kids are wearing for Halloween. That includes referencing them sometimes on calls. It's important that clients understand that you are not a robot too, and that you have other people that depend on you in your life too. But I really, I'm proud that we've got so many parents, especially in our healthcare privacy and compliance group. I was the only parent for a long time. And now I think we've got like 9 kids, not including mine. So I think 11 kids overall in our healthcare privacy and compliance group. And I think that's so exciting that people feel supported and they've got a model. And I don't do it perfectly. I certainly, there are things I could do better, but they see me still succeed and they see the firm supporting me while I do all these things. So the Halloween thread is kind of part of that.
Okay, so final question, and we'll let you get on with your, I'm sure, busy day. So what is something that you would like to tell every in-house counsel to pay attention to right now?
One thing?
Yes, one thing. There can be many, but just one you pick today.
In healthcare, we're very lucky that we are required to have privacy officers. And it's not just a name, they have big jobs that they're constantly being called upon. And so I think continuing to develop and have a close relationship with your privacy and compliance officers / team, because they're seeing things now, they're trying to prevent problems down the road. And I think sometimes it feels a bit Chicken Little, sky is falling. The bad thing will happen. I promise. And so not paying attention to, does this contract make sense? Are we appropriately limiting the transfer of data? Has this vendor agreement and situation really been vetted? That feels like such a speed bump. But if we don't deal with it now, it will become a problem in the near term that will be very expensive. And the compliance team doesn't want to say no. They want to say yes. They just want buy-in and support to get to a yes that is the safest yes possible with the reasonably anticipated risks addressed. And they're your partner. They're not a stop sign. So keep bringing them in and supporting them in their continued education so that they can continue to be a fantastic internal resource to both the executives and procurement teams and the boots on the ground.
Thank you so much, Aleks, for joining us today and for telling us about all the different pieces of your practice within the healthcare privacy and compliance space.
Absolutely, guys.
Thanks so much.
If you have any questions for David or Nichole, their contact information is in the show notes. As always, thanks for listening to Baker Hosts. Comments heard on Baker Hosts are for informational purposes and should not be construed as legal advice regarding any specific facts or circumstances. Listeners should not act upon the information provided on Baker Hosts without first consulting with a lawyer directly. The opinions expressed on Baker Hosts are those of the participants appearing on the program and do not necessarily reflect those of the firm. For more information about our practices and experience, please visit bakerlaw.com.